Ladies and gentlemen, welcome to the National Constitution Center. I am Jeffrey Rosen, the president of this wonderful institution. We are honored today to have a distinguished audience of federal judges from around the country, and I would like our members, who are loyal members of this congregation, to recite for our judges the mission that came from Congress and inspires us every day to do our work at the National Constitution Center. Here we go, Your Honors. The National Constitution Center is the only institution in America chartered by Congress to disseminate information about the U.S. Constitution on a nonpartisan basis. Beautifully done. Okay, excellent. In that inspiring nonpartisan spirit, we are so thrilled to present to you today the latest in a series of extremely meaningful collaborations with the Federal Judicial Center. Our topic today is judicial independence and the federal courts. We have done previous seminars on the legacy of Chief Justice John Marshall, on the meaning of Reconstruction and the First Amendment. And our previous collaborations have been spearheaded by the former head of the Federal Judicial Center, Judge Jeremy Fogel, who we're honored to have here today. And it's so exciting to present this collaboration with the new director of the Federal Judicial Center, John Cook, who has just done such a superb job in bringing this together, along with his great staff, Clara Altman and Marlon Holloway, who thank you so much for your wonderful work. And I'd also like to thank John Aguilera, whose support has helped make today's program possible. Judicial independence and the federal courts. It is impossible to think of a value more central to the rule of law than judicial independence. Let's inspire ourselves by reading from the canonical text defending judicial independence, Alexander Hamilton in Federalist 78, the rap star of the moment, noted that the independence of judges is equally requisite to guard the Constitution and rights of individuals from the effects of those ill humors which the arts of designing men or the influence of particular conjectures sometimes disseminate among the people themselves. And we're going to study today the history of judicial independence, the rich and dramatic series of clashes between the judiciary, the people, and the other branches of the federal government. We're going to talk a lot about two extraordinarily significant Chief Justices who contributed to our modern conception of judicial independence. The great Chief, John Marshall, and his distinguished successor, that underappreciated hero, the Judicial President and Presidential Chief Justice, William Howard Taft, who did so much to create the modern independence that we appreciate in the federal judiciary today. We're going to have three panels this morning: judicial independence at the founding, in the 20th century, and the 21st century, and we've just got an extraordinary group of scholars and judges to teach us about the historic roots and contemporary importance of judicial independence. And to lead us off, we have the privilege of my great colleague and friend Michael Gerhardt, visiting scholar at the National Constitution Center, professor at the University of North Carolina Law School, who will moderate and introduce our first panel. Please join me in welcoming Michael Gerhardt and his panelists.
Well, good morning. I have the great privilege of beginning our discussion today about judicial independence. And first want to introduce our two terrific panelists. To my far left, and I'm only speaking directionally, is Paul Finkelman, who's the president of Gratz College. And then to my immediate left, Alison LaCroix, who is the Robert Newton Reid Professor of Law at the University of Chicago Law School. Obviously, again, our topic is judicial independence, and it is a rare moment for us to be able to talk about something that the audience actually has a vested interest in. And this is a topic that is kind of near and dear to everybody's heart. But Alison, I thought I would start with you to really ask the very basic question about whether the Constitution mandated the creation of any particular kind of court system.
Great. Well, thank you. And yes, it's definitely a pleasure to be here. I think a good place to start, and I'm a historian in addition to a lawyer, is setting the Constitution in some historical context as well, and to ask the question of judicial independence from what or whom. So the people who drafted the Constitution and who were in the room a couple of blocks away, working on all of this material, really thought about the structure partly in terms of what they had known under the British Empire. I mean, that was very familiar to them, and they had those of them who were lawyers had trained in British law, both local law and imperial law. And I think their view was, one, it's important for the judiciary to be independent of the legislature. So we see this in Federalist 78. Hamilton says this, that the federal judicature, which I think was his phrase, it didn't quite catch on, but I still like it, that the federal judicature was intended to be this intermediate branch between the people and the legislature. So that's from one side, that they were thinking the courts need to be independent of a legislature, and they're thinking of parliament. And then two, I think this is sort of latent in the text of the Constitution and in the structure, which is a sense that at that time, the British Parliament was innovating in terms of parliamentary sovereignty. The idea was that whatever Parliament said was law. And in some sense, you had to wait for Parliament to correct itself if it got something wrong. So this was something that pamphleteers were writing about in America in the 1760s. And they kind of didn't know what to do. If Parliament says 2 + 2 = 5, you just have to wait for Parliament to correct itself. And the idea of the judiciary was, no, that is in fact the body that corrects the legislature. And then the final piece, I think, of judicial independence from whom or what is the crown, because a big part of the colonial controversy about judges was when the crown would start paying their salaries, and then there was a question about, well, who would they be beholden to? Would it be to London and Westminster or their local constituency? So the salary angle is a big part of it as well, and they were thinking in terms of independence there from a kind of prerogative executive power.
Okay, thank you. So, Paul, to what extent are lower courts, and I know that's a subject of keen interest for all of us, but to what extent are the lower courts central to this idea that Alison is talking about with respect to the creation of the United States judiciary and its commitment to judicial independence?
I'm sorry, I didn't.
So I'm asking, what's the role of the lower courts?
Well, the only specific court that the Congress has to create is a Supreme Court. It says there should be a Supreme Court and such lower courts, such other courts. The other courts, of course, are the trial courts. And at the convention, there is a great deal of discussion about whether they need lower courts, because many people would say, well, let the states try everything, and the Supreme Court can simply be a final arbiter. One of the reasons why people like Madison wanted to have a constitution and wanted to have a new form of government is to create courts that could be arbiters between states and arbiters of legal issues that come up between citizens of different states. Because before the Constitution is written, you go into New York and you win your case, and you then try to get the defendant in Pennsylvania to pay what the defendant owes you, and the Pennsylvania courts say, we don't have to listen to the New York courts, we don't care what New York did. So the idea that you have national courts will mean that you will have a national legal system for civil issues, for land litigation, for business litigation, which is in part what everyone is concerned about. And so one of the ways that they could have done it, which they talk about, is to have trials in the state courts, let the Pennsylvania state courts try a case involving a business transaction in Pennsylvania, and if one of the parties doesn't like the result, then you could appeal to this national court, the Supreme Court. But in the end, of course, they don't do that. In the end, Congress says, no, we're going to create a system of trial courts at the state level, but they will be federal trial courts. And then they create this completely crazy system, from our perspective at least, that the Supreme Court justices will also serve as circuit justices going out into the states and hearing trials. And so you have a Supreme Court that initially, of course, is meeting in Philadelphia, and at the end of the session, they go out to whatever states they are from, whatever states are in their circuit. And furthermore, the initial proposal, the Judiciary Act of 1789, has a system where the circuit courts will consist of 2 Supreme Court justices and 1 district judge. Mm-hmm. And they immediately discover that getting these Supreme Court justices to go out and hear cases is next to impossible. And what's crazy is that this system continues until the 1890s. And when you think about the change of the country, so that by the 1890s, you would have a Supreme Court justice having to leave Washington and go hear cases in California or Oregon, you can only imagine how dysfunctional the system works. Adams tries to change this, and President Adams in the Judiciary Act of 1801. Unfortunately, and I'm sure we'll talk about that in a minute, that act is so politicized and so political and so dumbly, aggressively political that it gets repealed with the Judiciary Act of 1802. But I don't know if you want to get to that yet.
We will get there, absolutely sure.
Could I do one footnote to what Alison was talking about? I agree with everything. But one other piece that's worth remembering is at the Constitutional Convention is a delegate from Pennsylvania named Gouverneur Morris. Now, he's oddly from Pennsylvania because he actually, most of his landowning and most of his life has been in what is today Westchester County and the borough of the Bronx. The Morris family owned about half of what is today the Bronx. That was, one of their estates. They also had a small farm in New Jersey, which today we call Morris County. And Gouverneur Morris was he came from this incredibly wealthy family. His grandfather had, among other things, owned more slaves than anybody else in the northern colonies. Morris was an abolitionist by this time. But the important point for judicial independence is this. Morris's father had been the chief judge of New York in the 1730s, and he had been involved in a prosecution of John Peter Zenger, who was a newspaper editor who wrote very nasty, unfair stories and articles about the governor of New York. The governor of New York would have said that this is all false news, and eventually Zenger is prosecuted for libel. And in the process of doing this, the governor of New York fires Chief Judge Morris from being the chief judge of the New York colony. So for the notion of judicial independence, you have somebody who has lived this with his own family, that his grandfather had been fired for being an independent judge. So that makes it very personal, it makes it very real to people, because they all know of this story. The Zenger trial is one of the iconic moments of the generation before the Revolution.
Well, thank you. So, Alison, I want to return to or focus more specifically on the notion of judicial independence. Mm-hmm. Obviously, that's going to be a critical theme running throughout all these, throughout our discussion and later panels. But I wanted to clarify to what extent did the framers have a well-developed sense of judicial independence, and what was that sense, and is it different than any sense we have of it today?
Yeah, well, I think they did have a clear sense. It's some of the themes that we've been talking about. So the financial independence, and this goes into the early republic, the sense that judges are political, and everybody kind of knows, of course, that they are political figures in many cases, but the sense that they are responding to or captured by, as we would now say, kind of partisan politics. So they were worried about that. But yeah, there were some surprises. I mean, I think there are things about the 1780s and 90s that just astonish us. And if you're teaching in a law school, saying you're teaching constitutional law or talking to lawyers, the idea that, what is this problem of invalidating legislation? I mean, I think that was what they were very concerned about. And a reason to have independence was, again, this idea of independence from the legislature so that the federal judiciary could speak on behalf of the Constitution. Marshall says that over and over. Hamilton had said it in Federalist 78 and others. But they didn't necessarily arrive at the convention here in Philadelphia thinking the courts would do that. So Madison and the Virginians came in 1787 with this plan that said, the real problem will be states being centrifugal. They often use these physics Newtonian metaphors. The states will sort of spin off into their own orbits. So this is a sort of federalism question about judicial independence. And Madison comes in and says, well, the solution there is to have Congress, and specifically the Senate, be able to negative or veto state legislation. So there, Madison was thinking, the legislature will do this, federal legislature to state legislature. And then Jefferson and Gouverneur Morris and others say to Madison, you know, that seems overly broad, and also a complicated setup of federal and state interaction in ways that I think we would find very surprising. Shouldn't we have the judiciary do this? Wouldn't the judiciary be better? Now, I think Jefferson might have thought this because he wanted to limit the federal footprint. But very quickly, others, Marshall, Story, and others going into the early 19th century, start building the federal judiciary as an institution. And they say, well, the federal judiciary, both through original jurisdiction, which they were trying to develop in some cases, and then through appellate jurisdiction, have this ability to keep the states in check. So I think they were thinking about independence in that functional kind of way as well, that the federal judiciary's job is to keep the planets in orbit, and the states were the planets they were especially concerned about.
Okay, thank you. Paul, to what extent does it matter or who the people are that are the judges? So who are the people being picked as judges in those days? And is that related to this concept of judicial independence?
Oh, I think it matters tremendously. And one of the things that I think is notable about judges today versus judges then is that virtually everybody who goes to the courts at this time has held elective public office. They are all people who have been politicians. One of the striking things about the U.S. Supreme Court, this is a test, who was the last Supreme Court justice to have held elected office in the United States? Sandra Day O'Connor was a member of the Arizona legislature, and she was the last person appointed to the court who had been an elected public official. Whereas if you look at the Supreme Court throughout the 19th century, and almost through the, I would say, post-World War II of the 20th century, virtually every person on the court has been an elected public official. There are people who are not. Felix Frankfurter comes to mind. Justice Robert Jackson had never been run for office. But by and large, these are people who came up from the bottom, had to shake hands, had to meet voters, had to interact with constituents on their way to the court. Joseph Story served in the U.S. House of Representatives before going to the Supreme Court. John Marshall had been in the Virginia legislature. He had been in the U.S. House of Representatives, and then he goes to become Secretary of State, and then he becomes Chief Justice. So in some of the early states, the judges are elected. So even if you were a state judge, you had been an elected official. That makes a very big difference in who you are as a judge, because you are much closer to the people you are making decisions about. And that's a tremendous change from then. The other thing is that at least at the Supreme Court, the notion was that the court was actually representative of the nation. For a while, the U.S. Supreme Court basically represented 4 of the 5 boroughs of New York. And then New Jersey. So you had a metropolitan New York, and we had a Chief Justice who was born in Buffalo. So that, and of course everyone in Staten Island said, why not us? So no one could have imagined that in the 18th and 19th century. In part because of the circuit system, but also in part because there was a notion that there should be a justice on the Supreme Court who represents a particular region of the country. And initially in the Judiciary Act of 1789, there is 1 district judge in every state, with the exception of Massachusetts and Virginia, which get 2 because there's a district judge in Maine, which is still part of Massachusetts, and there's a district judge in Kentucky because that's simply too far away from the rest of Virginia. I think around the 1830s, you begin to get 2nd district judges. And so when you get a 2nd district judge in New York, the judge is upstate, and you have an upstater who becomes the district judge. So there is again the notion that you're bringing justice to the people from the people. And that affects things. The other thing, of course, is who gets appointed. So one simple example: Andrew Jackson would not appoint anybody to the federal courts unless he was absolutely certain that they would support slavery. So you have a litmus test by Andrew Jackson. You must be pro-slavery to sit on the federal courts. He happens to make a mistake when he appoints Justice McLean to the U.S. Supreme Court, but he doesn't make very many other mistakes after that.
Thank you. So, Alison, as you know, some of those early appointments were made by the Virginia dynasty of presidents. Virginia was overrepresented in the early presidency. And one, of course, the most important appointments made during that time is John Marshall, who happens to be from Virginia, and he's the Chief Justice. Tell us about how Marshall, not just how he gets on the Supreme Court, but some of the early cases in which he's asserting the power of judicial review.
Yeah, well, I love the facts of Marbury versus Madison for many reasons. One, because you can always teach students them again and again, and they still are confused. And so it feels like there's always something new there. But I think one of the parts about it that I think captures a lot of this turmoil about the early period is the fact that John Marshall was the one who failed to deliver the commissions. John Marshall was sitting there with John Adams. They're cranking out the commissions on March 3rd, the night before Jefferson is inaugurated. And so I think that tells us, and then of course, why didn't he recuse himself? And so it gets to these questions of this permeability between the political branches and the bench in interesting ways. Now, I think another thing, and Paul alluded to this, is the Judiciary Acts of 1801 and sort of what was happening with the Federalists. So I think there's a standard story that Jefferson sweeps into power in the Revolution of 1800, and the Federalists sort of see the writing on the wall, and that's why Adams and Marshall were there closeted for hours signing all the commissions, because they thought, we have to entrench ourselves in the judiciary. That's our last bulwark against the oncoming Republican Jacobinical hyena of Monticello. That's the kind of thing they said. I'm channeling the Massachusetts people there.
Very well.
Yeah.
But you're not wrong.
I'm not wrong. A lot of hyenas. So that's one story. But I think another part of the story is this effort. So what did the Judiciary Act of 1801 do? I mean, one aspect of it is the circuit judges, then there are the justices of the peace, so that's what William Marbury's commission was for. But another part of it was federal question jurisdiction. And that was something that the Federalists and people outside the Federalist Party, a broad constituency of people in Congress had been talking about in the 1780s and 90s. So the idea that for the system to work, and people had different views about this, why this was a good way to do it, but if you were going to have federal courts at all, the national judicature, you needed to have those courts have original jurisdiction over federal questions or arising under jurisdiction. They use that phrase. And part of that was sort of render unto the federal system that which is federal. And part of it was also to say, look, the states are going to hear the most cases. But if you're concerned about the overall footprint of the federal government, you might want the federal courts to deal with their things, and then the state courts are the final arbiters on their questions, and then there's a fight about whether the Supreme Court will review those cases. So there are different reasons that people think the federal courts should have federal jurisdiction, broader jurisdiction. So that is established in the Judiciary Act of 1801 and exists for 1 year, 1801 to 1802. And then in the Repeal Act of 1802, that goes away. But it's really interesting to think about that in terms of, then you see through the 1820s and 30s, the jurisdictional side of what the Marshall Court was doing in many cases was not only expand Congress's powers to charter a bank and maybe do internal improvements and all these other substantive things, but also jurisdiction. They're trying to sort of claw back some form of federal question jurisdiction that actually hadn't been granted by Congress. And then it's not until 1875 that the predecessor to Section 1331 is passed. But This story, I think, complicates the idea that 1800 happens, the Federalists sort of run to the judiciary, and you don't get a rising under jurisdiction until the Reconstruction era. And there is this effort to do it in the earlier period that sounds in all these themes of, again, the states sort of going off into their own orbits, and also a sense that jurisdiction is really where how you form a union. The mechanics of courts, the lower federal courts, really matter.
Paul, I know you've just written a book about Chief Justice Marshall, and he is a complicated man, among other things. Tell us a little bit about the complications of Chief Justice Marshall, and particularly as they ultimately relate to later decisions like the Antelope case.
Okay, so Marshall is a brief biography. He comes from Western Virginia. He is described as running around the forest with a coonskin cap and a tomahawk in his belt as a young boy. He serves in the Revolution. One of the things that is important about Marshall is he not only serves in the Army, but he travels all up and down the East Coast. So he's in New York, he's in New Jersey, he's in Pennsylvania. He is a worldly man for a kid from the backwoods. Towards the end of the Revolution, he resigns from the Army, briefly studies law, passes the bar, immediately opens a practice in Richmond, and very quickly becomes quite successful. Again, he's relatively middle class at best. Unlike his cousin Thomas Jefferson, who's one of the wealthiest people in the country. But Marshall is very keen on changing that. So he spends much of his early years buying land, buying slaves, constantly buying slaves, actually. Even though he doesn't actually need that many slaves, because he's living in Richmond, he would need a few household servants, but he's buying land, populating land with slaves that he's buying until, I don't mean to sound arrogant about this, but until the book I just published, no one knew this, because all the biographers thought he only owned a few house servants in Richmond and didn't know about the 150 or 200 slaves out in the countryside that he'd been accumulating. He also is accumulating land. At one point, he owns about 200,000 acres of land in Virginia. This is a stunning amount of real estate. He becomes a leader of the Federalists in Virginia. He becomes an ambassador to France, or not actually an ambassador, but a diplomat sent to France. He is the one who exposes the XYZ affair, where the French government was asking for bribes from Americans in order to negotiate better relations with France. He exposes that. He comes back. He's a national hero. He's elected to Congress. He then goes into John Adams's cabinet as Secretary of State. And after Adams is defeated for the presidency, he is nominated for the Supreme Court and confirmed. Again, without trying to draw too many parallels to modern politics, it is worth noting that Marshall is the first of many justices nominated and confirmed in the last year of a president's term, and he happens to be nominated and confirmed after the sitting president has actually lost the election. So this is a fairly common practice up until the last 4 years or 2 years. And Marshall then goes on the court. John Adams, of course, says that John Marshall is Adams's great gift to the American people. The Judiciary Act of 1801 is very complicated, followed by the act which creates the government for the District of Columbia. So Marbury is actually not from the Judiciary Act of 1801. He's from a second act. So the first act reorganizes the court system, gets rid of the Supreme Court justices riding circuit, which makes all the justices happy, creates 16 new circuit judges, because now there are 16 states. Each state will have a circuit judge. Each state will have a district judge. The district judges and the circuit judges will work together in certain capacities, work separately in others, and then you could appeal to the Supreme Court. The Supreme Court now only has to live in the brand new city of Washington, D.C., and they don't have to go out and ride circuit. Had Adams been politically shrewder, he would have appointed 8 new circuit judges and perhaps said, I'm leaving to my successor the opportunity to appoint the other 8 new circuit judges. Had he done that, it's quite likely that the Judiciary Act would not have been repealed. But what Jefferson saw is that Adams created these 16 new judges, all of them appointed, all of them confirmed in a matter of minutes. And so in 1802, Congress repeals the 1801 Act. And this gets litigated in a case called Stewart versus Laird, which almost nobody reads except, historians who are interested in, the minutia. But what's interesting is in Stewart v. Laird, Marshall says that if Congress can create a court, Congress can also abolish a court. Marshall says that while you serve for life, you only serve for life if your court exists. And there's a difference between removing a judge because you don't like the judge and abolishing the court. So in theory, tomorrow Congress could put all of you out of work.
It's in the fine print of your commission, by the way.
And that would be legally permissible under Stewart versus Laird because Congress could abolish all of the district courts or all of the Court of Appeals in the United States. Marshall privately says that this repeal is unconstitutional, but he either because he's politically smart or shrewd or lacks the guts to challenge Jefferson on it, he upholds the repeal on the grounds that Congress does have the power to abolish the court. And then you get Marbury's case. Marbury is different. He was appointed to be a justice of the peace for Washington County, which is half of the new city of Washington, D.C. He is confirmed, his commission is signed, it is simply not delivered. And so Marbury sues asking the Supreme Court for a writ of mandamus to order the new Secretary of State, James Madison, to give the commission to Marbury so he can become a justice of the peace. By the way, you don't get paid to be a justice of the peace. It's purely honorific. You only make money if you actually hear cases. It's a fee-based job. So this is not about Marbury making money. This is about Marbury having the honor to be able to say, I'm Judge Marbury. This was a reward for loyalty to the Federalist Party.
Thank you. I'm going to come back.
Okay, all right.
We'll come back to that line of cases. I want to bring Alison in to discuss one of the other ways in which the Jefferson administration is perhaps threatening judicial independence, and that's through the use of impeachment, which is a very important development in those early 1800 years. So tell us about what happens on that front.
Yeah, well, this is a sort of pervasive theme throughout Jefferson's presidency, even before, which is the possibility of impeaching various judges. At certain points, Chief Justice Marshall, and Chief Justice Marshall, I think we have pretty good evidence, was very concerned about this, that this might actually be kind of coming. There's the impeachment of Justice Samuel Chase, which goes pretty far down the road, but doesn't go all the way. And Chase, so it's interesting to think, well, what are the bases for these? What are the ostensible bases for the impeachments? In Chase's case, it was a grand jury instruction he had given when he was riding circuit. And so the idea was that he had given this grand jury instruction and said essentially, and there wasn't great recording of it at the time, but it was reported in newspapers, that he had sort of talked about in the context of the Alien and Sedition Acts, what the job of the grand jury was, what the perils that awaited anyone who didn't sort of uphold the Alien and Sedition Acts. And so the view was that it was too political. Now, a caveat in all of this, I think, is that a lot of the justices and judges in the federal courts generally in this period were involved in politics. So it's sort of a question of at what point did it become too much? So in 1816, for instance, we know Justice Story is drafting legislation. I guess that's just what he had time to do in addition to all his other activities, teaching at Harvard, writing the commentaries, being a Supreme Court justice. And he drafts legislation, again, back on this question of the jurisdiction of the Supreme Court. So he drafts it and he sends it around to the other justices. This isn't sort of leaked under a pen name. Marshall signs on. The other justices, except for Justice Johnson, sort of say, yeah, this seems like a good idea. You should really send this to your friends in Congress, which he does. So that's happening. And so the judges and justices are deeply involved in these, what we would think of as political issues. But I think the way they were thinking of impeachment was as a robust tool that was, in some sense, the flip side of judicial independence, which was there's independence and independence from the legislature, and this is guaranteed and very important, but that in some cases, if judges were seen as going too far, impeachment was something that really could be wielded against them. And I think they didn't have a sort of set list of what the offenses would be, but it was things like the grand jury charge that Chase issued.
Okay, thank you. So, Paul, I want to you can pick up the story there.
Just quickly on the impeachment. Before the Chase impeachment, Congress, the House impeaches and the Senate convicts Judge Pickering, who's the district judge in New Hampshire. But everybody agrees Pickering is mentally ill. He's also comes to the court drunk many times. For an entire year, he never holds court at all. The great debate in the Senate is not should he be removed, because even the Jeffersonians think he should be removed. But, I mean, even the Federalists think he should be removed. But the question is, has he committed an impeachable offense? And when they read the Constitution, they can't find an impeachable offense. And he's nevertheless removed properly because he's incompetent and not doing the job. That sets the stage for Chase.
Yes, and so I want to come back to Alison on one more point before we get back to sort of more about Marshall. So Alison, you mentioned the courts focusing on jurisdiction as a way to, I think, perhaps consolidate its power and also push back against any efforts that were being made to kind of weaken the court. One of the critical decisions in that time period is not by Marshall, but it's by, I believe, a person who used to be a jurisprudence professor or a jurisdiction expert, and that's Joseph Story. Mm-hmm. Martin versus Hunter's Lessee is one of the important cases that deals not with the overturning of federal laws we've mentioned, but with the overturning of state action. So tell us about the importance of that in the development of the court's exercise of judicial review.
Yeah, so Martin is one of the great cases, I would say. So, and it goes to the Supreme Court twice. From Virginia, and the basic question is ownership to this vast tract of hundreds of thousands of acres of land in Virginia, the Fairfax lands. Marshall owned some of this property that Paul was mentioning. Marshall had significant property interests and speculative dealings in that land, so he did recuse himself in Martin. So it's always interesting to think, not when you're the Secretary of State who fails to deliver the commissions do you recuse, but when you have a property interest, then you recuse. So that's part of how Story comes to write the opinion. But what's very interesting to me about that case in a kind of jurisdictional structural sense is the fight that goes on between the Virginia Court of Appeals, which is the highest court in Virginia at the time, and the Supreme Court. And the case goes up to the Supreme Court and then back down to Virginia when the Supreme Court says, in essence, title should vest in the Fairfax heirs who were holding through a chain of title that implicated the federal treaty that ended the Revolution, versus the Martin side who were claiming under a Virginia patent. And so the Supreme Court sends it back to Virginia and says, okay, Fairfax wins, sort of carry this out. The Virginia Court of Appeals refuses, and they say, well, we've made our own assessment. And they cite the Supremacy Clause in an interesting way because the Virginia justices say, the Supremacy Clause of the Constitution says, and the judges in the states shall be bound thereby. We are bound, and our understanding of all the way of these various land claims interact is that the Virginia title vested first. And then the Supreme Court reviews the case again, and then this implicates this question of, can the Supreme Court review state courts, the decisions of the highest state courts? So then Story writes the opinion and says, no, essentially, no, really, we really mean it. Section 25 of the Judiciary Act of 1789 is constitutional, so Congress has given the Supreme Court the authority to review you, Virginia Court of Appeals. Second, this is classic story. This is where I think he's more Marshall than Marshall. He says, and by the way, we don't even really need Section 25. It's nice that Congress has given us this, but it is latent in Article 3 itself. It's the case, not the court, that gives jurisdiction. And he just kind of goes off. But something that I really particularly like about this case and find very interesting is the opinions of the Virginia judges. So one of them is Spencer Rowan, who's a famous foe of Marshall in McCulloch and the Bank cases. He's usually, and rightly, discussed as a hardcore state sovereigntist. And that's true, but there are other judges on the Virginia Court of Appeals who share these various views. And one of them is Justice William Cabell. And so Cabell says, and they write seriatim opinions, the Virginia judges. Cabell says, well, the Constitution has created no umpire. He uses the word umpire. Therefore, the state courts have to be the final courts that decide these issues. There isn't this appeal to the Supreme Court. It doesn't have that position that it claims. And then Story takes this up in his opinion. Actually, the advocates in the Supreme Court talk about this. But it's, I think, really interesting, and this comes up in some of the background reading for today, this umpire idea, because there's Cabell saying, the Constitution has not created an umpire among the states.
Okay, thank you. So we have 2 minutes left, which I'm going to stretch a little bit, but just a tiny little bit. But with that in mind, I want to come back to you, Paul, to talk about what happens in the aftermath of Marshall's death. And I know we're speeding up this story, very, no pun intended, very fast. But I'm glad you paid attention, thank you. And so with respect to what happens after Marshall's death, Jackson appoints Roger Taney. Tell us about the big decision he writes, which he may try to defend as an exercise of judicial independence.
Well, Taney is synonymous with the Dred Scott decision, and what's important for this discussion is that we talk about Marbury versus Madison as the great case that establishes the power of the court to declare an act of Congress unconstitutional. And when is the next time that the court does this? It's Dred Scott. It's 50 years later. So while Marshall establishes judicial review of federal laws, the court never exercises this again. Even where it refuses to enforce a federal law, it kind of wheedles around it. It doesn't say, we're declaring this law unconstitutional. Taney in Dred Scott says that the Missouri Compromise, which is the most important political compromise of the first 50 years of the United States, which says that there will be no slavery north of the southern boundary of Missouri or west of Missouri, settles the problem of slavery in the territories. Taney says that is unconstitutional, and furthermore that Congress can never regulate slavery in the territories because slavery is a national institution and you can take your slaves anywhere. I think as a matter of constitutional law, he's certainly on strong ground for some of this. That is, that slavery is deeply embedded in the Constitution. But clearly the political consensus since the very beginning of the Constitution was that Congress can regulate slavery in federal territories. Taney believes what he's doing is settling the problem. From Taney's perspective, the debate over slavery in the territories had been going on since the end of the Mexican War in 1848. In 1850, Congress passes the Compromise of 1850, which settles some of it in favor of slavery. Then you get the Kansas-Nebraska Act, which repeals part of the Missouri Compromise and allows slavery in what is today not only Kansas and Nebraska, but also the Dakotas and Montana. And really by this point, the only place where slavery is not allowed is in the Northwest, Oregon, Washington, Idaho, and in Minnesota. All of the rest of the federal territories, Nevada, Utah, Wyoming, everything south of that, slavery is legal in all of these places. And in 1856, this new party, the Republican Party, led by John C. Fremont, runs on a platform of free soil, free labor, free speech, free men, as in no slavery in the territories. The Republicans do very, very well, but they don't win. And so Taney is saying, look, the nation has spoken. Congress has spoken. The electorate has spoken. Now I will speak and just end this issue for everybody. Right. But he does it in a way that is so sweeping and so arrogant that what he ends up doing is catapulting his most articulate critic, a mostly failed politician, railroad lawyer from Illinois, into the White House in 1860, because Lincoln eviscerates Tawney all across the North, not only in his famous debates with Douglas, but speeches all across the country, eviscerating this opinion, pointing out how inconsistent it is. For one thing, Tawney begins by saying Dred Scott can't sue because even if he's free, black people can't be citizens of the United States for purposes of federal jurisdiction, which is clearly must be wrong because blacks voted in 6 states when the Constitution was ratified. And so Tawney reaches this conclusion and then says, and by the way, even though we don't have jurisdiction, we're going to decide that the Missouri Compromise is unconstitutional.
Let me get to Alison in our negative time now, if I may, with just one of the other mechanisms that is used both at the beginning of the Republic and then later, as late as 1869. One of the mechanisms used to sort of deal with the court from the perspective of the political branches, and that mechanism is changing the size of the court. Mm-hmm. So tell us what's the size of the court at the beginning, and what's the size at the end?
Well, and so as your question suggests, I mean, it varies much more than we would think. So, first of all, there are points even during Marshall's tenure where people aren't showing up because they're sick, or there's a sort of big gap between about the 1833 term and 1837. Charles River Bridge is held over because so many people have died or retired and so on. So, you're talking about 5 to 7 justices for much of that time, and then it sort of increases later in the 19th century. But yeah, it's something that, again, we often tend to think of as kind of set, but in this period, and people talk about expanding it, certainly also, so that's a discussion as well. It's long before 1937 and Roosevelt, there's discussion about increasing the size of the court, packing or adding, or increasing geographic representation. That's sometimes also something people think about.
I wish we had more time. We don't. I know there's another terrific panel on judicial independence coming. I appreciate your patience. Thank you. Thank you both.
Thank you.
Thank you so much, and welcome to our panel on judicial independence in the 20th century. We are honored to be joined by Stephen Burbank, the David Berger Professor for the Administration of Justice at the University of Pennsylvania, and author of landmark articles including Judicial Independence, Judicial Accountability, and Interbranch Relations. And Tara Leigh Grove, Professor of Law at William & Mary, and author of equally important articles, including The Origins and Fragility of Judicial Independence. Stephen and Tara, we just heard this great discussion about how in the 19th century there were threats to increase and decrease the size of the court and to strip the court of jurisdiction. We begin the 20th century with threats to overturn judicial decisions by popular referenda and to recall judges for unpopular decisions and to overturn judicial decisions by votes of Congress. And then we have the Great Court Packing Plan in the middle of the 20th century, which is fought back. And by the end of the 20th century, we have landmark examples of the judiciary standing up to the executive in the federal and state systems, including Cooper and Aaron ordering the integration of public schools, and U.S. v. Nixon, the unanimous decision ordering the president to turn over the tapes. I want to begin with Chief Justice Taft. I have had the pleasure of writing this book about him for the American President series, and was impressed by the fact that he was a presidential Chief Justice and judicial president. He approached every decision as president in constitutional terms, asking, did the Constitution allow the action, unlike Theodore Roosevelt, who asked, did the Constitution prohibit it? He yearned to be Chief Justice and fought the election of 1912 on the question of judicial independence, believing that Roosevelt and Wilson, by endorsing populist attacks on judges, were the equivalents of demagogues. And we have in the reading this dramatic quotation from Chief Justice Taft: "The agitation with reference to the courts, the general attacks upon them, the grotesque remedies proposed of recall of judges and recall of judicial decisions, and the resort of demagogues to the unpopularity of the courts as a means of promoting their own political fortunes, all must be lamented." Taft becomes Chief Justice, and he has three great achievements: the Judiciary Act of 1922, creating the Conference of Circuit Judges; the Judiciary Act of 25, giving the Supreme Court control over its own certiorari jurisdiction; and building the magnificent Supreme Court building, symbolizing the Supreme Court as a fully equal branch. Judge Doug Ginsburg was here to talk about the Taft book, and he called Taft the second most important chief after Marshall because of his role in shoring up the independence of the federal judiciary with the Judiciary Acts that I just mentioned. Is that a fair assessment? And please evaluate, if you will, Chief Justice Taft's role in protecting judicial independence.
I think it is a fair characterization. For most of our history, federal judges conducted their judicial business in solitary splendor. The concept of the federal judiciary was more notional than it was an organizational reality, and it's not surprising, therefore, that the concept of judicial independence was associated primarily with individual judges rather than with the separate third branch of the judiciary. Taft's reforms changed all that. They enabled the federal judiciary actually to function as a third branch through greater efficiency in management of the affairs of the courts, the effect that that had on judges in federal judges who might have thought of themselves as conducting separate duties, and that they all had something in common to pull for, and Taft was a remarkable person in terms of his political skills. He had vast networks. He kept in touch with people. He made most federal judges understand that they would better hang together rather than separately. And so by creating what we now call the Judicial Conference of the United States, putting in place, although it didn't happen until he had died, the mechanism that gave the Supreme Court of the United States the power to promulgate rules of procedure through the Rules Enabling Act of 1934. Taft was really responsible for that. Indeed, early on in my career, I found in a dusty archive in Des Moines, Iowa, the eureka moment of any young scholar, namely a letter from Taft to Senator Albert Cummins of Iowa, which is why I was in Des Moines, in which Taft had included a draft of the second section of the Enabling Act of 1934, as it was in fact enacted. So he was very actively involved in politics, but he was also, again, a good politician. So rather than himself go to testify in favor of what was called the Judge's Bill, the act in 1925 that converted most of the Supreme Court's docket into a discretionary docket, he sent over some of his colleagues who were very effective in testifying in favor, including George Sutherland, who of course had been a senator and was testifying in front of some of his former colleagues. Ultimately, in 1939, again after Taft had died, but I think we can give him a good deal of responsibility for it, you had the creation of the Administrative Office of the United States, and more important, a transfer of the budgetary power from the Attorney General of the United States to the judiciary. So if you put all that together, I think it's a fair characterization of Taft as being next to Marshall, and in some ways even more than Marshall in terms of the judiciary as a branch of government, an independent branch of government. he deserves an enormous amount of credit.
That is wonderful for those of us who are Taft admirers to hear your high estimation. What an amazing eureka moment. You know, it was while he was president, Taft made basically a State of the Union speech saying the reform of civil and criminal procedure is the most urgent question facing America at this moment. Can you imagine a president saying that in prime time today? And it was that led him to propose in 1923 the act that became...
Well, may I
please
add to that? It is interesting. And I think not just with the benefit of hindsight, that Taft represented a lot of reforms that had deep substantive and political resonance as involving efficiency. Thus, in the period that you were referring to earlier, he characterized so much of what he wanted to do in terms of efficiency, even though he well knew it had to do with power.
Tara, your estimation on Taft, I'm very eager to hear it. You have written that judicial independence is as much a convention or a norm as anything compelled by law. And yet when we think of Taft's reform, his great achievement was as an administrator. Henry Stimson, who served as Secretary of War under Roosevelt, Truman, Taft, and Hoover, said that Taft was the greatest administrator of them all. And as described by Stephen, his reforms were primarily administrative. Was that the key to his contributions to judicial independence, or was it his personal leadership, or do you have a different estimation of his role in promoting judicial independence?
So there are many fun things to say about William Howard Taft. You alluded to one of them. He said he was president of the United States, but his dream job was to be Chief Justice of the United States. And I don't think many people can say that. One of my other favorite notes about Taft, in 1912, when he lost the election to Woodrow Wilson, he actually called it a win because he had defeated Teddy Roosevelt's attacks on the federal judiciary. He wrote to a friend after the election, "Yes, we pulled this one out. It's good," which you don't hear from many presidents who are now lame duck. So I think he really believed in judicial independence. That was, however, not a focus of his chief justiceship, probably in part because although there were attacks on the federal judiciary during that period, those were not the key moments of the attacks. I think he was trying to build the federal judiciary for the long term. And I think you've alluded to some of his comments. Steve has alluded to some of his contributions, and Steve has alluded to some others. But I want to talk about another thing that Taft did, and that was to change the notion of the Supreme Court's role within the federal judiciary. And this was part of his efforts to build the federal judiciary as an institution. So he did many things on the administrative side, but in advocating the Judges Bill, the Judiciary Act of 1925, Taft had a vision of the US Supreme Court. Prior to that time, a big part of the Supreme Court's job was to correct errors in the lower courts, to make sure they were doing the right thing. And he thought that was not at all what the US Supreme Court should be doing. That was in part because of capacity constraints. The Supreme Court's caseload had gone up to about 1900 by the late 19th century, and they were able to bang out maybe 400 to 500 cases out of the couple thousand that were on their docket in the early 20th century. Now, note, 400 to 500 cases per year. A little bit different from the 80 they sometimes put together in today's world, but
with fewer law clerks.
With fewer law clerks, they decided 400 to 500 cases per year. But Taft said, look, we're deciding a whole bunch of cases that we shouldn't be deciding. The Supreme Court should no longer be a court of error. It should be a court that sets general principles of law for lower courts to use in many cases. I know many people in the room are judges who try to make sense of Supreme Court decisions, so one can question how good of a job they do in clarifying the law, but that was the vision that Taft had of the US Supreme Court, and you see this throughout the 1920s and in his testimony, both leading up to and on behalf of the Judges Bill, saying we need certiorari jurisdiction so that we can choose those cases where we can define those general principles of law. The idea being that just like we have hierarchical systems in many other areas, we should have a hierarchical judiciary with the Supreme Court setting the basic boundaries and then the lower courts applying those principles in specific cases. And I think that was a major contribution to the judiciary, even if it wasn't focused on judicial independence.
One of Taft's other great goals, in addition to his administrative achievements, was massing the court, persuading the justices to speak in one voice, and converging around unanimous opinions, often written by the chief. And in this sense, he was inspired by his hero, the great Chief John Marshall. He was remarkably successful in this goal at the beginning of his chief justiceship, persuading even former opponents like Brandeis and Holmes to join him in unanimous opinions, because he said, I don't generally approve of dissents. But by the second half of his chief justiceship, the court began to splinter, partly ironically because of the Judiciary Act of 25, which, by allowing the court to focus on controversial constitutional cases and avoiding the technical ones, created more division. And that division increased on the way up to the New Deal, culminating in the series of 5-4 decisions that led to the court packing plan. So, Stephen, what can you tell us about the chief's role and judges' role on appellate courts in general of promoting judicial independence and institutional legitimacy by creating unanimity and collegiality, and what was Taft's contribution to that?
It's often important that there be an adult in the room, and the Chief Justice can be that adult in the room. We see it in Taft. I think we see it in our current Chief Justice. When your colleagues are so bound up in their particular views, sometimes it requires that the Chief Justice remind them that they are part of a larger enterprise, and that the legitimacy of the Supreme Court, what political scientists call diffuse support for the Supreme Court, is absolutely essential to its continuing function as an independent branch of the government, free of undue influence by the executive or the legislature. If the Supreme Court of the United States and the federal judiciary as a whole loses what the late, great Richard Arnold called the consent of the governed, then they will lose their independence. We haven't talked about judicial accountability, but only a lawyer can think about judicial independence and not think about judicial accountability. They're different sides of the same coin. No society would want judges or courts. And let's remember that Article 3 of the Constitution invests not judges, but courts with judicial power. No society would want completely independent courts that were free to decide cases any way that they wanted. The society wouldn't be able to operate. So you have to have a certain amount of accountability. You have to have a certain amount of political influence on the courts. The tools that preserve in the Constitution judicial independence, life tenure, and a secure compensation, are in fact not adequate at all to protect judicial independence. There's so many ways, formal and informal, in which the political branches can influence the federal courts, that without norms, or as Tara has called them, conventions, we would be in deep trouble. The judiciary would be in deep trouble. So to get back to your question, Jeff, the Chief Justice of the United States, and it continues to astonish me that even very bright people sometimes refer to him as the Chief Justice of the Supreme Court. The Chief Justice of the United States has a unique role to play, and I'm happy that Taft was in that role because he was very good at it.
Tara, tell us about court packing and the role of Chief Justice Hughes and the conventions, as you put it, that emerged from it. There was the most dramatic example of the 20th century of an effort to influence the court by changing its numbers. It was rejected, and ever since then, as you note, at least throughout the rest of the 20th century, the notion of court packing was unthinkable, although it is now back on the table. So tell us what it was about the defeat of the court packing plan that contributed to judicial independence throughout the 20th century.
I published a paper in March of 2018 saying that court packing was the single most off-the-table court curbing measure, which I believe was true in March 2018. And that seems to be changing, and that really brings us back to earlier period and what actually happened in 1937. So a couple of things about that. Roosevelt announced in 1935, right after the decision in Schechter Poultry and a few other decisions, that he wasn't going to stand for the U.S. Supreme Court, striking down all the New Deal legislation. And he tells the press, my Department of Justice is working on this. We're not going to stay in this horse and buggy era of constitutional law. He doesn't say very much at all publicly, says nothing at all, virtually nothing at all about the U.S. Supreme Court in 1936, thinking that might hurt his election chances. But it turns out that U.S. Department of Justice was working very hard behind the scenes to try to figure out what to do about the U.S. Supreme Court. And they looked at a lot of options. They thought about stripping Supreme Court jurisdiction. They thought about imposing supermajority requirements on the U.S. Supreme Court, which is another proposal that other people had made in the early 20th century. They thought about a variety of things, but finally decided that the single best way to change the U.S. Supreme Court was packing the Supreme Court. In a very long memo, one high-level Justice Department person said, we need to change their decisions. Now, when FDR finally proposed this in February of 1937, that's not the rationale he gave for court packing. As I suspect many people in this room have heard, Roosevelt said, well, you know, we need some new blood in the judiciary. These justices need a little bit of extra help. They're obviously not able to decide all their cases even after the grant of certiorari jurisdiction. And you know, the younger guys might be able to just do a little more work, a little faster. And he says a few other things, but people kind of get the subtext, but he's not talking about the subtext. And so Chief Justice Hughes comes back and said, actually, we're fine. We can do our jobs. We're absolutely well staffed. And also points out, and this is something that had been debated in the 19th century as well, if we have more people, it's going to take a lot longer to make decisions. Because it's hard enough to get 9 people to stop talking and actually to come to a ruling. Imagine if it were 10, 11, 12, 13, 14, or 15. And those of you who have been in en banc courts and the courts of appeals, I'm sure know exactly this problem. So Chief Justice Hughes refuses to comment on the merits of the court packing plan, but at least undercuts this rationale, I think, in a very powerful way. So Roosevelt comes back and says, okay, here's the real reason. The real reason is we have a Congress and a president who are working hard to change the constitutional vision of this country. We are looking for a constitutional vision that will help the working man. And there is one branch of government that is completely cutting against this crucial constitutional vision that will uphold minimum wage laws, uphold maximum hour laws. And that's the U.S. Supreme Court. And American public, that needs to change. Now, I think a lot of times when we hear about the court packing plan in U.S. history, we hear Roosevelt proposed this plan, people thought it was crazy and absolutely raced against it. And then it was smashed in defeat, ruined Roosevelt's presidency, and he regretted it forever. I think sometimes that's the story people are told, and that's just flatly not true. In fact, Roosevelt's plan came very close to passage. Even if he might not have gotten a 6-justice court packing bill as he initially proposed, there's a very good chance he would have gotten a 4-justice court packing plan had it not been for the death of the chief proponent, Senator Joe Robinson. And of course, as we all know, possibly also had it not been for the Supreme Court's change in direction. The so-called switch in time that changed 9. Now, one of those decisions, West Coast Hotel versus Parrish, there are a lot of debates about that decision because the vote in the U.S. Supreme Court had occurred well before, the internal vote in the U.S. Supreme Court had occurred well before Roosevelt announced his plan. But that wasn't the only case where the Supreme Court kind of switched on social and economic legislation. In other cases, like Jones and Laughlin, the Supreme Court also ruled in favor of either federal or state power to regulate economic conditions. And that also significantly impacted the success of the court packing plan. But I have argued there was not a strong norm against court packing even in 1937, even after the failure of Roosevelt's plan. And we see some evidence of that in the early 1950s when members of Congress proposed a constitutional amendment to fix the size of the U.S. Supreme Court at 9. That constitutional amendment also would have made it impossible to strip the Supreme Court's appellate jurisdiction over constitutional claims. In discussing that constitutional amendment, people didn't say Roosevelt had violated a norm. They said, this is something that almost passed about 15 years ago. We need to protect the U.S. Supreme Court from future packing attempts by passing this constitutional amendment. Now, that amendment passed the U.S. Senate by a pretty wide margin 6 days before the U.S. Supreme Court decided Brown versus the Board of Education. After that, there was far less support for the amendment. And now some progressives opposed it because they thought that this is it's a bad idea to fix the U.S. Supreme Court. Maybe we'll need more justices later on. But after Brown versus the Board of Education, I think a lot of support was lost among the more conservative members of Congress as well.
Go ahead.
And so the final thing I'll say is, I believe that the current norm as of March of 2018 against court packing came largely from political rhetoric, because when there were court curbing proposals thereafter, people would denounce it. People on both sides of the political aisle, Republicans and Democrats, would denounce whatever, whether it was a jurisdiction stripping measure, something else, a particular nominee they did not like. They would denounce it as, this is just another court packing attempt. So such that court packing became a political epithet as of March 2018.
Let me thank you, first of all, for that extraordinarily illuminating account of court packing and reminding us of the contingency of its failure. Just as in the 19th century, the size of the court fluctuated, you remind us that it almost succeeded, and it was rhetoric and the bipartisan opposition, both in Congress, where congressional Democrats like the vice president denounced it, as well as on the court, where it was Louis Brandeis, who was the conduit between Chief Justice Hughes and Congress, helped to defeat it. Stephen, with your important work, basically your reflections on what it was that killed court packing in the 30s and what the lessons are for it, whether it might succeed today.
Well, I mean, Tara's account is, I think, absolutely right. I would add two different possible contributing factors. One, there were people, including progressives, who were concerned about the aggregation of power in the executive and thought that the court packing plan, if it were approved, would represent another step towards perhaps a too powerful executive. The other, which will be near and dear to many people in this room, is that before the court packing plan came up for a vote, Congress passed legislation that made it possible for the first time for justices of the Supreme Court to assume senior status. That had not previously been permitted because of concern that you could have 20 people on the Supreme Court. There was an obvious answer to that, the answer that was adopted in 1937, and that is that when a justice assumes senior status, he or she may retain the office but cannot continue to do judicial work on the Supreme Court. Some people thought that that legislation was proposed as part of the campaign against Roosevelt's plan. That's not accurate, because the legislation, in fact, had been proposed before, the year before Roosevelt's plan was known. It was proposed because Congress was chagrined that although in 1869, when Congress first provided the opportunity for federal judges to have a pension, the concern had been expressed, well, if they get off the courts, give up their Article III positions, then their pensions could be cut. That was treated derisively, go, we'd never do that. Well, in fact, they did do it in the Economy Act of 1932, which cut Oliver Wendell Holmes's pension by half. And Congress felt very ashamed of themselves for that. And the remedy was to permit an alternative to resigning your Article III post, namely, you keep your Article III post, you can't continue to participate in the work of the Supreme Court, but you can do what justices have done since then, which is to sit, some of them, with lower courts. Although it was correctly responded to the claim that this was done to defeat court packing, no, it wasn't. But Hamilton Fish, who was perhaps Roosevelt's chief antagonist in the House of Representatives, was openly gleeful that the passage of this legislation would doom the court packing plan. And indeed, shortly after the legislation was passed, one or more members of the Supreme Court retired from the Supreme Court, but they retired in senior status, and therefore their pensions were protected.
Thanks for those two very important insights about the internal incentives for judges to retire and the external desire not to consolidate too much power in the executive. Tara, I want to answer this basic, broad question. Why was it that for the rest of the 20th century, in the midst of some of the most controversial challenges to the executive and Congress in our history, from Brown versus Board of Education to Cooper and Aaron to Watergate to Roe v. Wade, the norms of judicial independence and against court packing essentially continued. And you note that norms in the nominations process, like the filibuster requirement, were only repealed at the beginning of the 21st century. Things started to get more polarized beginning with Robert Bork, but even for most of the 80s and 90s, we had lopsided confirmation for justices. And it seems to be in the 21st century, as the next panel will observe, that those norms are breaking. So why did the norms persist, and what began to challenge them to fray?
So one of the things that led me to look into the history of judicial independence was academic scholarship, actually. And I'll say I started the research on that in fall of 2015, at a time when no one thought judicial independence was in trouble. So I wasn't trying to, foreshadow something. I was actually looking historically. Why is it that people talk about jurisdiction stripping so much? And academics talk about it. These proposals are actually made in Congress, and nobody ever talks about what happened in 1802, firing Article III judges by abolishing their courts. Hardly anyone talks about, until very recently, defying federal court orders or court packing. So my goal was to try to figure this out. And I think there are multiple reasons, but I think one of it is the way that we talk about our federal judiciary. The way we, meaning in part academics, have talked about our federal judiciary. Starting around the 1960s and 1970s, academics offered a really powerful story to support stripping federal jurisdiction. They said, look, this is a way to legitimate federal judicial decisions. If we know, this gets back to Steve's point about the sort of political accountability is important to judicial independence. If we know that Congress can strip federal jurisdiction whenever it wants to, then that really supports the idea that when federal judges have jurisdiction to make decisions, this is basically a license from Congress for them to decide as they think makes sense. What was interesting is this story, which has makes some intuitive sense, could also be told about court packing. If you know that the president and Congress could come and pack the Supreme Court whenever they want to, that would legitimate, arguably, judicial decisions, because when they don't do it, that's kind of a license from president and Congress to keep doing what you're doing, and we're fine with it. But academics didn't tell that story about court packing throughout the mid to late 20th century, even as they did tell that story about jurisdiction stripping. I think it's a hard question as to why not. I think that many people in both legal academia and in Congress were really bothered by the mess of 1937. And I think that's why court packing became the political epithet. We'll do lots of stuff to the federal judiciary. We'll propose jurisdiction stripping measures, but we're not going to do that thing that Roosevelt did later on. And then once something picks up in terms of political rhetoric and becomes a political epithet, it takes on a life of its own. So all the way up through the proceedings over Merrick Garland, people used court packing as a political epithet. Republicans justified not holding hearings on Merrick Garland on the ground that the Democrats, in their view, had packed the DC Circuit in 2013 by abolishing the filibuster for lower federal court judges and putting 3 judges on the DC Circuit Court of Appeals and then putting lots of other people on the federal courts. Republicans said, well, you tried to pack the court and that therefore justifies what we're doing now. What's interesting to me now is that the rhetoric is changing on court packing among academics. So far, members of Congress are saying, well, you know, we're looking into it, but they haven't embraced it. It's coming from constitutional law scholars. And this is actually something I'm writing about right now. And that, to me, should scare people who care about judicial independence, because when you look at the mid to late 20th century, one thing that was helping to make court packing a political epithet and something that was off the table is that scholars didn't talk about it as something that was on the table. I found one proposal in 1973 after Roe versus Wade where a conservative scholar suggested court packing. I suspect no one in this room has ever heard of that, because it was completely off the table at that time. And now scholars are changing their rhetoric. But the other thing that I think is very interesting about the current period is that unlike Roosevelt's plan in 1937, the current rhetoric is not about a specific judicial decision or even a particular trend in judicial decisions. Roosevelt was angry about what the Supreme Court was doing. People today are angry about what senators did, what presidents have done. This is coming entirely externally from the judiciary. Progressives are angry that Merrick Garland was left complete without a hearing. They talk about Justice Gorsuch as filling a stolen seat. The Brett Kavanaugh hearings were something, and I'll just leave it there. But certainly did not look good for the federal judiciary. That's what's driving these allegations, something entirely external to the federal judiciary. And that means, in my view, that federal judges cannot be the sole source of judicial independence. People also have to think about protecting judicial independence and the appearance of judicial independence in the way that we select our judges in the presidency and the Senate.
Thank you very much for that. Steve, the same extremely important question to you, and I'm so eager for your answer. Why did norms of judicial independence persist for most of the 20th century? Why did they begin to fray at the beginning of the 21st? And what do you make of the new rhetoric among academics and others endorsing court packing that would have been unthinkable for most of the 20th century?
Well, I'm going to try to stay in the 20th century.
Good. Well, that's our panel, so that we can do that.
And I support scholarship just as it supports me, but I don't have much illusion that most federal judges pay much attention to what scholars have to say. I don't think the views of scholars are particularly important here. I think that the views of the public are, however, and it is worth noting that modern polling really only dates to the 1930s. Polls have consistently shown that the courts in general and the Supreme Court in particular have much greater support among the public than does the Congress. The executive, it fluctuates a little bit more. So I think that's part of it. I think that Keith Whittington is right that one of the, and I'm quoting him, one of the notable developments of the 20th century in the American judicial system is the rise of a bipartisan commitment to judicial independence and robust constitutional checks on the power of elected officials. A key moment that has hardly been referred to in these discussions so far is Watergate. For people of my generation, I'm 71, Watergate is, a very, very important moment. For me, it was particularly important, and forgive me a personal story. I had the privilege of clerking for Chief Justice Warren Berger. And on my first day at work, I spent the morning going around filling out forms, and then I had lunch. And then I went back to my office, and a messenger arrived with an envelope and said, "This is from the Chief Justice. He would like you to proofread this opinion." It was the Nixon tapes case.
Wow.
So the notion that no person is above the law for somebody who lived through...
Sorry, were there any typos?
That's confidential.
Okay. We'll subpoena the answer.
The notion that no person is above the law was very powerfully enforced on people of my generation, perhaps a little bit more powerfully on me. And that principle was, of course, again vindicated in Clinton against Jones. And so I think Watergate and the unanimous opinion of the Supreme Court in the Nixon tapes case did much to cement bipartisan support for the Supreme Court, because it showed us that at times of real peril for our democracy, the one institution that perhaps we can rely on is the federal courts.
Wow. Well, we're going to have just lightning rounds of closing statements, and I'm just going to ask each of you, if you had to identify, based on the lessons of the 20th century, a single thing that the federal judiciary, the Federal Judicial Center, or the National Constitution Center could do to promote judicial independence in the face of threats today, what would it be? Steve, first to you.
It would be to constantly reinforce the notion that judicial independence and judicial accountability are joined at the hip. That it makes no sense to talk about judicial independence without talking about judicial accountability. That if the federal judiciary shows itself to be properly accountable, it will preserve its judicial independence.
Thank you for that. Tara, last word for you. A single thing that the Constitution Center, the Federal Judicial Center, or the federal judiciary could do to promote judicial independence.
I think it's important for people to see the examples that push against their presuppositions. I think far too often the media is talking about 5-4 decisions on a certain subset of subjects, abortion, affirmative action, and so on, where judges make predictable responses. And what people don't hear about is the number of federal appeals court decisions that are unanimous, which is the vast, vast majority of them. The number of Supreme Court decisions that are unanimous. And how can that be if people are just politicized? And I think making that a larger picture of how we visualize the judiciary would be extremely important to preserve that diffuse support that the courts so desperately need.
Ladies and gentlemen, we're going to take a 15-minute break, but for all they have done to shed light on the question of judicial independence, please thank our panelists. Superb and riveting.
That must be my brother.
Yes, there we go. Need the audience.
Welcome back. Thank you. Again, welcome back. My name is John Cook. I'm the director of the Federal Judicial Center, and we're very proud to co-sponsor this program with the National Constitution Center. Just as an aside, in addition to our mission to educate federal judges and others about their jobs, our statute charges us with the study of federal judicial history. So this is a kind of a dual purpose program for us. And in addition to the NCC Twitter site, I just cite you to the Fed Judicial Hist at Fed Judicial Hist on Twitter, and you'll see daily updates on issues affecting the federal courts throughout our history on that site. Now, for our last panel this morning, which is sort of brings us up to today, I'm very privileged to be joined by Chief Judge Diane Wood. She's Chief Judge of the Seventh Circuit Court of Appeals, sits in Chicago. She was appointed to that court in 1995, and by District Judge John Bates, who is a district judge in the District of Columbia. He was appointed to his position in 2001, and in each of their roles, Judge Wood currently serves as a member of the Judicial Conference of the United States. Since she's been a chief judge, she's been in that role. Judge Bates was the director of the Administrative Office of the United States Courts from 2013 to 2015, and we'll return to those roles and those entities in a couple of minutes. But since our basic topic here is judicial independence, I thought I'd begin by asking each of you, what does judicial independence mean? And we've talked about, Professor Burbank mentioned that it can't be just an unconstrained power. So what are some of the limits on it that you see as judges? So Judge Wood, would you like to start?
Well, thank you, John, and it's a real pleasure to be here. When I think of judicial independence in the positive sense, I think of the freedom to decide each case as it comes along in accordance with the law as I understand the law to be. And in some ways it may be helpful to think of what might prevent that from happening. And if one steps back and looks at the experiences of judiciaries around the world, you can see that sometimes there's a threat to independence that comes from political sources. It's known that you hold your office at the pleasure of some political figure, a president, a prime minister, a governing party, and so we see examples where independence is compromised that way. We see examples where independence is compromised through economic factors. Maybe a judge is just not paid well enough, and so there's a threat of bribes. We have a current issue that is brewing in the judiciary from the economic standpoint, and it's this. As you may know, federal judges who have served at least 15 years and who have attained the age of 65, so it's a rule of 80. You add your service and your number of, and your age once you hit 65, you can either retire or take senior status from the federal judiciary with your full salary, essentially, for the rest of your life. I'm oversimplifying only a little bit. Now, a lot of judges do, at some point after 65, when they attain that status, they will take senior status, at which point they continue to sit as judges, sometimes with a full caseload. I have a colleague who's 92 who's still taking a full caseload, sometimes with a reduced caseload, and they're still subject to all the normal judicial rules. But what we're starting to see is people who leave the judiciary at 65 or 66, and they go back to a law firm, or they go into arbitration, or they do something else. And so people have begun to question, are they in some ways compromising their judicial independence because they see the next job down the road? I have no evidence that they are, and so I don't want to leave anyone with the impression that that's happening, but it's a question that is beginning to be asked with increasing frequency. The third form of compromise is what I'll call a bureaucratic compromise. There are some countries in which the chief judge has tremendous power over what the judges on that person's court do. Let me assure you, I have zero power over what the people on the Seventh Circuit do, zero. But I can think of countries where if you're not pleasing the chief judge, you wound up being sent to some remote, not particularly attractive part of that country, and so on. So my last point is just I give you this example only to show how extraordinary it is. Twice in my time in the Seventh Circuit, since 1995, I've actually been involved with a live case in which a member of Congress has tried to intervene in the case and tell the court what that member of Congress thinks we should do. And the first one involved, of all things, the identity of the person who was going to represent the United States in the Sydney Olympics in 2000 for the 75-kilogram weight class of Greco-Roman wrestling. I didn't even know there was a sport called Greco-Roman wrestling until I got this case. But there had been an arbitration in Chicago, and so the case came to the federal courts in Chicago in the guise of an effort to enforce an arbitral award. And so our court, I was on the panel, with of course 2 of my colleagues, we ruled that a man by the name of Matt Lindland would be that person in the weight class. Well, this enraged a member of the Senate, and he took it upon himself to write us a letter and tell us that we'd gotten it wrong. It needed to be the other guy. This is while the case is still pending. There was a petition for rehearing filed, and so we did file also an opinion on the rehearing saying we actually didn't care what this member of the Senate had to say about this. I think we tried to say so politely. And then a lot of other things happened, and actually the funny coda to this is that he did win the silver medal. So we chose well, and then he had a career as a mixed martial arts fighter, and he nicknamed himself The Law. So the very absurdity of it, I actually had one other occasion when this happened, but it's so unusual. Federal judges do not get pressured from either Congress or the executive branch to decide in a certain way. And I think I'll talk about accountability mechanisms maybe at a later point. There are many of them, particularly if you're a lower court judge, it's called the Supreme Court. But if you're in the federal judiciary, we have ways of handling that.
Judge Bates?
Thank you for having me here today. It's a pleasure to be with you. I do think judicial independence definitionally has 2 parts. It's been mentioned somewhat already today. The individual or decisional independence, which is really the ability to make fair and impartial decisions, free from external influences. But there's also an institutional judicial independence that is more thought of as part of the separation of powers, the capacity of the judiciary to serve as an autonomous, co-equal branch of government. And I think they're both important when thinking about judicial independence. There's some constitutional roots, but as you've heard from others today and in the reading materials, it's not all set out in the Constitution. It really has evolved over time, particularly on the institutional end. On decisional independence, that fair and impartial decision making, it's not just independence from improper external influences, but it's also fidelity to certain things. You have fidelity to the rule of law, to basic fairness, to appellate review. which is part of our process. And then there are other accountability and restraints that affect the judiciary, and we'll talk about some of them here today, I think. And it's important to think of judicial independence on the individual side as having both those accountability aspects as well as those freedom from external influence aspects. On the institutional side, it can be complex. Freedom from encroachment by the political branches is how I think most people would think of it, and therefore preservation of the separation of powers. But there are only so many constitutional protections: tenure, salary, advice and consent probably is one as well. And a lot of this has evolved over time, as we've seen and heard in the reading materials. And Chief Justice and President Taft obviously has had a lot to do with that. But there have been these pressures on the judiciary institutionally over the course of our history. And they've been pretty significant at times. Reducing jurisdiction, court packing, all of those kinds of things have really been threats to the judiciary. I do think the threats to the judiciary are probably a little greater now than they have been at some other times. I'm not sure that I fully agree that that public officials don't occasionally pose some threats to independent judicial decision-making. I think that does sometimes occur, but the judiciary is pretty resilient, and I have some confidence that things will work out all right, but it's going to take some effort, I believe, over the course of the coming years. Those are some initial thoughts on judicial independence.
Well, I want to come back to some of that, and particularly to the accountability piece. We heard in the last session about Chief Justice Taft and his efforts to establish some of the institutions that we now enjoy in the judiciary, particularly the Judicial Conference and the Administrative Office. And Judge Wood, you're a member of the conference, and Judge Bates, you had the pleasure, I guess, of being the director of the Administrative Office for a couple of years. And a lot of our audience may not be as familiar with those agencies and what they do. Could you just talk about them for a minute and how they support judicial independence?
Sure. The Judicial Conference of the United States, which is what has evolved out of those original proposals by Chief Justice Taft, is a body chaired by the Chief Justice of the United States, and it's comprised of the 13 chief judges of the circuits 1 through 11, plus the DC Circuit, plus the Federal Circuit, and there is one district judge representative also from each of the circuits. It's a person from the Court of International Trade for the Federal Circuit. So altogether, 26 people chaired by the Chief Justice. It has standing committees that are designed to do everything that's needed for self-governance of the judiciary, and that's a very important part of this overall independence theme. The judiciary is not governed by some branch of the Justice Department. It's not governed off in the ether somehow. It has a very conscious self-governance apparatus. So there's a budget committee. There's a committee on resources for the courts. There are many committees that are standing committees, including my old favorite one, the Standing Committee on Rules of Practice and Procedure. There is also a committee on codes of conduct. So this committee is the expert committee on the set of rules by which judges are expected to comport themselves. And it will give advisory opinions to a judge who has a problem coming up and the judge wants to know, is it okay if I go to this dinner if I'm the honored guest and it's for Save the Whales, or whatever it may be. They will give advice about this. They also publish a compendium of opinions, so you don't have to ask them to reinvent the wheel all the time. You can do some research yourself and see if the activity that is being contemplated is consistent with the rules of ethics. There's also another committee with maybe a harder face on judicial conduct and disability. There's actually a statute that Congress passed that covers the topic of judicial conduct and disability. And that statute reflects the fact that the impeachment process, perhaps because of Justice Chase, perhaps because of the passage of time, is simply not really available for every last problem that comes up. And I think there's a sense that if the judge's problem is, let's say, Alzheimer's disease, the idea of impeaching a judge because that judge has Alzheimer's disease seems to us in today's world a very harsh outcome. So the statute allows either kind of problem to be resolved, and it's actually the chief judge of the circuit that's the central actor in this, evaluating complaints that come in, appointing a committee if necessary, recommending to the circuit council, which is the governing body inside each circuit, what to do, and it can ultimately go back to the judicial conference. If need be, it can go and has gone occasionally to the House of Representatives for possible impeachment. But it's a very well elaborated process that any member of the public can initiate. You don't have to be some kind of specially privileged insider. And it's the judiciary's effort to say, we are trying to hold ourselves accountable to serious rules.
Judge Bates?
I'm going to go a little bit beyond the administrative office to talk about the administration and internal governance that Chief Judge Wood has mentioned part of, and how that relates to judicial independence. All of this, of course, comes in part from the Taft reforms that helped to create a structure within the judiciary with the Chief Justice at the head and a hierarchical, even a bureaucratic structure, if you will, on the administrative side, part of which is the establishment of the Judicial Conference, and part of which in 1939 ultimately was the creation of the Administrative Office and the Director of the Administrative Office. The Administrative Office is part of the centralization, if you will, of the administration and governance of the judiciary, and it's an entity of about 1,000 people usually, most of whom are located in the Thurgood Marshall building next to Union Station in Washington, headed by the director of the administrative office, who's appointed by the Chief Justice with the approval and agreement of the Judicial Conference. And as John said, I had the, I'll say, pleasure and honor of serving in that role at the request of Chief Justice John Roberts for 2 years. Usually that position is not filled by a judge, but there was a period where it was filled by a judge. Together with the administrative office, though, there is the Judicial Conference, and then there are the circuits. And they all work in tandem in terms of administration and internal governance. The administrative office supports the Judicial Conference and the committees of the Judicial Conference. As Judge Wood said, there are 26, I think, committees, and they cover a whole range of topics, and I'm glad that Steve Burbank mentioned the rules, and the Chief Judge Wood has mentioned the rules, and I do have the pleasure right now of serving as the chair of the Civil Rules Committee, and it's a wonderful committee. But all those committees are the way that policy issues percolate up in the judiciary. The national, if you will, the broad policy issues are developed through the committees and ultimately, for the most part, passed on by the Judicial Conference. And the Judicial Conference is that body of 26 judges. It does change from year to year. The Chief Justice is the 27th member. I think there's only been one occasion where the Chief Justice actually had to vote to break a tie. So he's not usually a voting member, and the director of the administrative office is the secretary of the Judicial Conference. But the administrative office operates sort of like a small executive branch agency, covering things like budget. It has the primary responsibility for dealing with Congress on the budget, and then responsibility for distributing that budget throughout the judiciary. Information technology, HR, conduct and disability, financial reporting, conflicts, interface with the legislature on pieces of legislation. All of those things are done through the staff at the administrative office. There is nothing more important than the budget, probably, in terms of an accountability constraint on the judiciary. And administratively now, within the judiciary, that is done mostly there, dealing with Congress to pass the budget. Conduct, policy making, all of those are accountability constraints that I think come out of this administrative and self-governance process that is a combination of the Judicial Conference, which includes all the circuit chief judges, the Chief Justice at the head of the administrative side of the judiciary, the administrative office with the director. There's an executive committee of the Judicial Conference that does a lot of the work of the Judicial Conference. Right now, that is headed by Merrick Garland, the Chief Judge of the D.C. Circuit. That is a very important body for the administration and governance of the judiciary. But the circuit chief judges are essential because a lot of the work, a lot of the administration, a lot of the governance takes place in the individual circuits. And I think you can't ignore the fact that it's a combination of centralization and a decentralized system that gives a lot of the autonomy and power and authority and responsibility to the various circuits, and particularly to the chief judge of the circuits. All of that, I think, is a part of accountability that helps to preserve judicial independence, both individually. It enables judges to focus on their docket and decide cases free from lots of worries and external influences, and institutionally, because those administrative and governance issues, if they are stable, respected, and efficient, which I think they generally are, that means that we don't have external pressures in the same way, either from the other branches of government or the public.
Let's come back to the accountability piece, and you've each touched on a couple of aspects of it. I think it would be useful to address some of the jurisprudential restrictions or limits on what you can do with a given case, and then on, again, besides the judicial conduct and disability procedures, what are some other ways that judges hold each other accountable for what they do?
Sure. Let's distinguish for the moment between the Supreme Court on the one side and everybody else on the other side. Such inferior courts as Congress shall from time to time ordain and establish. That's us. For the district courts, for the courts of appeals, what I'll call substantive accountability. What's going to prevent a court from going off the reservation, imposing its views in a matter that maybe judges have no business talking about, or in a manner that is inconsistent with either the Constitution or some statute that Congress has passed or some widely held understanding of Supreme Court jurisprudence? The simple answer to that is the appellate process. If there is the occasional rogue district court judge, and occasionally there is.
Why did you look my way?
You know. You have a couple of tools. There can be an immediate petition for writ of mandamus, and I can think of a couple of times when they have come to the Seventh Circuit. The example that I'm thinking of is of a district judge somewhere in our circuit who was annoyed that the U.S. Attorney's Office in his district was going to drop a case. Well, the executive branch is the group in our system which has the responsibility to prosecute. So if the executive branch thinks that it should dismiss a case for reasons best known to itself, maybe lack of evidence, maybe an important witness isn't going to work out, whatever, that's the executive branch's call. So this judge took the step of appointing a special prosecutor to continue the case, and there was an immediate petition for mandamus. We said, you're right, you know, this is the prerogative of the United States. We instructed the district judge not to do that. So that's an off-the-reservation kind of example. Certainly at the Court of Appeals level, I'm sure you can think easily of the kinds of cases in which there's at least vigorous debate these days about how far can the courts go. What can the courts say about a travel ban? What can the courts say about religious monuments in public? What can the courts say about sanctuary cities? What can the courts say about any number of other topics? Any of you in this room will have no trouble thinking of some examples. So these are hard questions. Reasonable people can disagree on them, but if the courts of appeals resolve those questions in a way that's incompatible with what the Supreme Court thinks, the Supreme Court will tell us so. Now, we are not unrealistic. We know that out of the 7,500 or so petitions for cert, petitions for review that come to the Supreme Court, it's only going to take 1%. On the other hand, no circuit judge worth his or her salt has any trouble identifying from his own circuit or her own circuit the 10 or 20 cases that might attract Supreme Court attention. Most of the cases are unanimous. A study I did suggested that across the country in the courts of appeals, 97% are unanimous. So the Supreme Court's there. What holds them accountable? Scholarly opinion does, Congress does. I think a sense of the importance of the role. The justices are all well aware that, as the saying goes, we're not final because we're infallible because we're final. I think that was Justice Robert Jackson who said that. So we have a lot of ways, short of these formal processes, to ensure fidelity to the law.
I think it is fidelity to the law that it is very important. The appellate process is obviously important. That belief in the rule of law is something that I think all judges share, just as pretty much all judges share a belief in the importance of judicial independence. Let me just step back a second. With respect to judicial independence, I've thought of one other definition of judicial independence. When I first came on the bench, two judges, one a former judge of the D.C. Circuit, another from the opposite side, a present judge of the D.C. Circuit, each independently said to me, "You will know when that you are a real federal judge the first time in a significant case that you decide against the president who appointed you." And I think there's some truth in that. I think that happens, maybe not every day, but it happens occasionally. And it's a way to think about judicial independence. You're there not to follow a party line or the beliefs of someone who got you into the position, but to follow the rule of law and to reach that fair and impartial decision based on the facts and the law before you. But there are all of these accountability constraints on us, both big and little. Certainly fidelity to the law is essential to how we hopefully conduct ourselves. But there are constraints coming from, what Congress can do vis-a-vis the budget is an institutional constraint. The executive has to, we hope, and thus far in our history, it's generally been true, setting President Jackson aside, that the executive will carry out the orders of the judiciary. And there are constraints that occasionally come up in terms of these things like possible court packing, jurisdictional limitations, and so forth. All of those things exist institutionally, but I don't think individual judges think about that very much when they're deciding cases. They're influenced, I have no doubt, as the current empirical studies establish pretty much, they are influenced by all sorts of things that are not 100% pure. They're influenced by their experiences, their background, even their ideology. I think judges have to work hard to prevent too much influence from those things. But certainly studies have shown that those are influences on judges, those are pressures on judges, and we know that the judicial confirmation process is pretty much broken. But certainly the primary thing that the president looks at when picking a judge, or the first thing at least, is usually their politics. You know, where do they sit on the spectrum? 90%, I think the studies show, 90% over the last 40 or 50 years, 90% of judges have come from the party of the president nominating them, and in the Supreme Court, that's even a little higher these days. So there are lots of pressures, and it's ultimately public opinion that does matter a lot. That is something that we cannot afford to lose. If public opinion is lost, if the public does not believe in the judiciary, then I think judicial independence is really at risk. As I think it was Steve Burbank mentioned, the judiciary still gets a little higher review from the public in terms of confidence. I think the last Gallup poll, 2018 Gallup poll, put the judiciary at 68%, the executive at 45%, legislature at 35%. That's significantly better, but it's more and more at risk these days.
Yeah, I'd like to pick up on that point. I've said elsewhere that one of the big challenges facing the judiciary and public institutions generally is this diminishing public trust in institutions across the board. And while the judiciary fares better than our other branches in those polls, being on the top deck of a ship that's taking on a lot of water is only a relative advantage. So what can the judiciary and what can judges do to try to preserve that trust?
There have been well, there are two ways of thinking about that, or two approaches. I don't think they're mutually exclusive at all. One of them is to build or perhaps rebuild the tradition of the judiciary of explaining carefully the reasons why a result is what it is in any given case, and doing one's work as much as possible in public. And by that, at the Court of Appeals level, what I mean is hold oral argument. Don't just have a case come into the maw and then emerge later in a written format that no one knows anything about. No one knows where it came from. Was it written by a law clerk? Was it written by the judges? Did the judges ever really read the briefs? We may know internally what we do, and I'm very proud of the way the Seventh Circuit does its work, and I'm sure my colleagues on other circuits feel exactly the same. But public accountability means letting the public understand and see what you're doing. And I think the pressures of increasing caseloads have caused the judiciary to adopt lots of practices in the name of efficiency that we're starting to see have come at some cost on the dimension of transparency. And I think we need to redouble our efforts and get back out into the open and make sure that the public knows that we're doing the job that we were assigned to do when we were given the honor of serving as federal judges. Now, there's a different approach. Many courts in the country, and we're all being encouraged to do this, are also trying different forms of outreach to schools, to students, to younger people, all in the nature of improving civics education. I think that's all fine, but I actually think at its heart, we need to do better ourselves in our core job. And I will just, this is a footnote to what John just said, I think another safeguard in terms of making sure that both the independence and the accountability criteria are being met is the fact that at least at the Court of Appeals level, no judge does anything by him or herself. nothing happens until at least 2 members of a panel of 3 agree on the outcome. So we are constantly dealing with people with different life experience, with different political backgrounds perhaps, and it's our job to sit there and carefully and courteously come to a decision. And we do most of the time.
And that's not a constraint that applies as directly on the district court level, although there are certainly peer pressures that exist. But I think that on the appellate level, that is an important constraint. You need to get someone else to agree with you, although it may be that one other person agrees and one other person doesn't agree. So it's not an overwhelming quorum. I think that we have to think not just of how the judiciary collectively acts. That's very important. We need to educate the public. We need to be engaged with public education. Transparency, explanations for our decisions, explanations for what we do are essential. And I fully agree that we need to be having more arguments on the appellate level, on the district court level as well. That sometimes is true. A lot of district judges are very busy and they don't hear argument in that many cases. But to the extent that time allows, I think letting the public see the judiciary in action is very important. Now, judges don't have the same platform in terms of speaking out to defend judicial independence or other important doctrines. There has been some recent activity by members of the Supreme Court. Most of you are familiar with Chief Justice Roberts recently saying that we don't have Obama judges or Trump judges, Bush judges or Clinton judges, and really defending the independence of the judiciary and that's something that is very important. He's not alone in saying that. I think Justice Sotomayor elsewhere in Pennsylvania at Duquesne out in Pittsburgh recently spoke along the same lines, saying that judges don't belong to a president or a party, but to the rule of law. And observing that, yes, there are a lot of 5-4 decisions. Are they partisan? Justice Sotomayor said, not really. What they are is there's a toolbox, and judges approach judicial decision-making based on utilizing the tools in the toolbox, and different judges use different tools and reach different conclusions. Unfortunately, as she admitted, many of those tools are associated with one or the other side of the political spectrum. But nonetheless, I think it's an important concept. And Justice Kavanaugh, in his confirmation hearings, spoke to judicial independence, called it the first quality of a good judge, not to be swayed by political or public pressure. And he mentioned cases that have been mentioned here today. Youngstown Steel. These are cases in which he observed the judiciary, the Supreme Court he was talking about, needed to have backbone. Youngstown Steel, with a president during wartime wanting to do something. I think you could look to Brown v. Board of Education. The political pressures were enormous there, and the Supreme Court issued a unanimous decision. And then the United States versus Nixon case, where a Chief Justice appointed by President Nixon got a unanimous court to decide that the president had to respond to a criminal trial subpoena and disclose information. And those are important things to bear in mind. But the judiciary can't do it all alone. This public education, public defense of judicial independence needs to be done by the bar as much or more than the judiciary. It is generally. We need bar organizations, leaders of the bar, to speak up and defend judicial independence against the threats that are currently posed. The threats aren't unique to this time. They're a little different, perhaps. I mean, we probably have more public official criticism of judicial conduct and particular judges and what they've done or courts and what they've done, high public officials criticizing that, than has been true in recent history. But it's not unique, and presidents have problems with judicial decisions that the Supreme Court issues frequently. Most recent presidents, I'll think of two examples, have said, well, not two presidents, one who wanted to be president, Vice President Gore, at the conclusion of the Bush v. Gore case said, I disagree with it, but I accept it. And President Bush, there a couple of years thereafter, when he faced some defeats from the Supreme Court dealing with the counterterrorism measures, first in the Hamden case, and it wasn't really an equal battle, it was the president in wartime against the former driver and bodyguard of the most despised terrorist ever, Osama bin Laden. That's not exactly an equal battle, but when the Supreme Court decided that a military commission was not properly formed to prosecute that individual, and then later, when in other cases the Supreme Court said that the treatment of Guantanamo detainees was not proper under the Constitution, President Bush said, I disagree, but I accept the decision of the Supreme Court, will follow it. So presidents have problems with Supreme Court decisions. President Obama did in a State of the Union speech once. But I think we're facing a little bit more in terms of really focused public criticism of particular judges on particular decisions and courts all the way down to the inferior courts than we have before, and it's much more personal. And I think that does pose more of a threat to judicial independence than we've seen in recent years. And we need the public, forums like this and other forums, to help to speak out to defend judicial independence.
You've both touched on recent comments by the Chief Justice and Justice Sotomayor. There's not Obama judges or Bush judges. At the same time, confirmations are political Armageddons, which suggests that this is going to be the end of the universe if this person gets confirmed or doesn't get confirmed. So there's kind of a disconnect there. Is there an answer to that?
You know, John, I think what you're touching on in some ways is media, and in some ways is reality. And I want to link what you said to what John was just mentioning about the 5-4 decisions and take it all the way back to the Judges' Bill of 1925. In 1925, we made a huge public policy decision, which was that the Supreme Court was not going to be an error correction body. It wasn't going to be a regular old court. It was going to be a body devoted to resolving the most difficult legal issues, the most important legal issues we have coming before the country. And that turned it, frankly, into a body with pretty large political valence. We need somebody to be the last word on these questions. Going all the way back to Marbury, we've decided that it's going to be the Supreme Court. And I would defy any of you sitting in this room who is not a judge, if I were to give you a plate of 8,000 cases, and I told you all, pick out the 80 that you think are the most important ones, and let's see how you come out on them, you might be the equivalent of 5-4. These are tough issues. They're issues that reasonable people are going to resolve differently very often, maybe not always, but it's that very selectivity that causes us to have these pressures that we have today. The media likes a good story, of course. They like to portray, contending factions and people who can barely stand each other. Although if you listened to Justice Ginsburg and the late Justice Scalia, they were the best of friends. They understood they had different viewpoints. They each sharpened the other one's opinions and helped each one make the best case for that viewpoint that could be made. So it isn't really this pitched battle. The confirmation process, televised as it is, all of this, we want a good story is also something that perhaps sometimes there really is a serious matter that should be investigated. Perhaps sometimes it doesn't require quite the breathless approach that's given to it. I think the only thing I can say is I remember, and actually my confirmation process was very tame compared to some of what's been going on. But I remember thinking the day I walked in, finally once and for all confirmed that I had just been through what was easily going to be the most political period of my life. I told people that I felt like a bill. But then it was over. I was able to shut the door. I have these wonderful protections from Article 3 of not really life tenure, as Justice Blackmun reminded me, serving during my good behavior. Hopefully I've lived up to that, and the salary protection. So I think, difficult though it is, and I worry about whether people are deterred from standing to be a judge because they don't want some particular, ill-advised incident when they were a college sophomore to be aired. I don't know. But we might be paying a price for this kind of attention.
I think we are paying a little bit of a price. The confirmation process is extremely polarized. It's to some extent broken, but it's a reflection of our society, which is polarized. It's not the cause of the polarization, it's just a reflection of it. So how do we deal with that? You can't just focus on the confirmation process and think you can fix that. It's the overall polarization in the country, and I don't have an answer for how we get that back into a more civil discourse and ability to make compromises, work with each other. It's something that is a real problem for us as a society. The confirmation process for inferior courts still works pretty well, although if you look at it these days, you can see that a lot of the judges going on to the appellate courts are by votes that are split right down the middle, Democrat and Republican. Almost exactly. You might have one or two people shifting sides, but it's really an amazing thing that has happened. That was not true 10 years ago. I'm not controversial, obviously. Not important is the more important point as a district court judge. And I had been a member, I was actually the deputy independent counsel for the Whitewater investigation. Very political event. And nonetheless, I was unanimously confirmed by the Senate, including Hillary Clinton as one of those senators. That wouldn't happen these days. That just wouldn't happen today. And I don't have an answer for how we fix that other than education to the public and somehow starting to work better together. I know that's a sad note.
Well, it is a sad note, and one has to ask whether the nature of the nominees has changed as well, because back in the day of the filibuster, you did have to find nominees who were going to attract some support from the other side. So it might have had an institutional pressure to find people who were not out at the extremes of whichever party happened to be in control. I think this is not a party comment, it's a structural comment. So if you had to find somebody who was somewhere in the middle, then the chances of getting a stronger vote were also there. I think if you're going to pick the most extreme Democrat or the most extreme Republican, you're changing the nature of the process.
Over the course of the morning, we've gone from the beginnings of the Republic and a very tiny judiciary that basically consisted of a few judges and justices to the beginning of the 20th century, where the start of a larger apparatus grew, and now today we have a federal judiciary of about 2,000 judges and about 25,000 employees, and the structure that we've described. What do you see next? Do you see this changing at all? Let's look internally. We've been talking about the external forces that deal with that affect the judiciary, but what can or should the judiciary be doing itself to change how it operates, or maybe not at all?
Well, when, you're including the bankruptcy judges and the
Yeah,
magistrate
you're right,
judges.
right.
So one thing that has happened is we've moved from a judiciary in which we have just Article III judges, district judges, appellate judges, Supreme Court justices, to a judiciary that includes two very important groups of judges who do not have the life tenure and salary protection from the Constitution. Those are the bankruptcy judges who are selected by the Court of Appeals in each circuit on a merit basis, and they serve for a 14-year term. You know, you can do the arithmetic yourself. 2 14-year terms, 28 years, that sounds like a pretty good career. But they don't have the same Article III protections. And the bankruptcy court itself is technically a division of the district court, so that's kind of where it parks. And we also have magistrate judges who do a lot of different things. It depends on how the district judges and how the district court wants to handle things, but a wide variety of actions in support of the district court, up to and including, if there's consent, actually holding a jury trial and resolving the case, but managing discovery or doing arraignments or doing, you know, search warrants, or a whole huge number of things they do. So in other words, one answer to our problem has been to expand the judiciary as the demand for federal judicial services increases. I think there's a bit of a schizophrenia about whether we really want cases in the federal courts or whether we are happy to rely on our colleagues in the state courts, and we haven't talked much about them, but we should be talking about them because they do 90% of the judicial business in the United States. They're crucially important, and there's a real variety of ways in which the state judges are selected. They don't have the kinds of independence protections we have, and yet, on the whole and by and large, they serve independently, with some sobering reminders, such as, you know, the voters voting out a bunch of judges on a state Supreme Court because they didn't like the outcome of an opinion. That has happened more than once. So there are other proposals that would send more cases into the federal courts, maybe every case in which at least one person is from a different state. There are some proposals that would strip jurisdiction from the federal courts and say you shouldn't be in the, you know, some business or another. The federal courts, on the whole and by and large, don't do family law and probate and some of these other areas, which are of course important to people, but they're not our business. The federal courts are increasingly clunky as a forum for resolving small claims experienced by a large number of people. You know, your classic claim where you paid $15 extra for your rental car at the airport, but who's going to sue for $15 when the filing fee is $400? I mean, you're not going to do it. You're just going to grumble and take your loss. There was a class action rule. There is still a class action rule that theoretically allows this to happen, but it's not. It's becoming more difficult to use. So we're either going to have to rely more on the state courts for things, or we're going to have to say we need to find better structures in the federal courts, whether it's through more judges, whether it's through better procedures. I'm not sure that these efficiency measures, though, are the answer.
I do think it's important to think of state courts in this context. More cases are decided in state courts, obviously, many more than in federal courts. And the state courts and judges are under greater pressures often than are the federal courts and federal judges through the electoral process or through legislation in some states to curtail the independence and decision-making of judges. Lots and lots of statutory attempts in the state courts to really tamp down on judicial independence, and I think we need to be concerned about that. I'll sort of take a different approach and more of an internal, what's going to happen internally within the judiciary with respect to some of these self-imposed constraints. And I think we are doing some things that help the public's perception of the judiciary. Some of them are perhaps a long time coming, but I think of the recent efforts with respect to addressing a structure for any sexual harassment or similar complaints about treatment of employees. And there was the Chief Justice initiated something that came in the wake of a bad incident involving the federal judiciary, but initiated a group to look at that, and they came out with a report. Now each of the circuits is looking very seriously, and some have already come up with revised plans. I think that kind of internal addressing of conduct issues is important. Our conduct and disability process is continually being tweaked and being made more robust. It's important. It happens both at the circuit level and at a committee of the Judicial Conference level. It gets a lot of public attention when something becomes public with respect to a judge's disability or inappropriate conduct. Putting on my rules hat for a second, I do think that we're looking at some of the things about the federal docket and whether unique rules are necessary for those unique areas. We have an enormous percentage of the federal court docket in what is called multi-district litigation cases. These are collective cases given to a particular judge to handle the preliminary activity in the case. But the preliminary activity is often the heart of the case. Discovery, motions, maybe even settlement. Those multi-district litigation cases account for over 40% of the federal cases. It's an amazing number that are in the multi-district litigation. We also have like 18,000 Social Security cases filed every year. And on the rules side, we're looking at, okay, do we need to do something with respect to rules that are usually trans-substantive? They aren't specific area rules. Do we need to consider something for these unique areas of the federal docket that are either without rules, the MDL process doesn't really have a distinct set of civil rules, or maybe you need special rules for something like Social Security. Now, we've resisted that in other places, patent cases, for example, but it's something that we're always looking at and seeing if there are improvements that will give justice more efficiently and more fairly, and the secondary result of that is that it improves the perception of the federal courts in terms of how they are dispensing justice.
We have about 2 minutes left, so I'll ask each of you if you have any last thoughts of hope, despair, inspiration, whatever.
My sense is that the underlying health of the federal judiciary is very good, and that we are very fortunate to have a group of judges, all of these judges, these 2,000 judges you're talking about, which honestly for a country of whatever we are now, 330 million people, isn't that many. They are doing a great job. I do think that the public's confidence in the judiciary isn't what I would like to see, and I think part of that is based on legitimate complaints. We are not doing enough to make ourselves visible, and we can't expect people, to march down to the courthouse every Tuesday and find out what's happening. There's more streaming of cases. There's more televising. I mean, we're trying to move into our panel is called the 21st century. So I'll make a 21st century point. The Ninth Circuit pioneered this streaming of all of its oral arguments but the Second Circuit now does it in some cases. The Third Circuit now does it in some cases. Our court, the Seventh Circuit, has adopted it for some cases, with the thought that we will also revisit this and perhaps take the next step and go along the Ninth Circuit's line. We're using video appearances more. We're trying to make things, in short, accessible to people so that they will see what we're doing, and if they're interested, they can read the briefs, they can make their own mind up, and I think they would be very pleased with what they saw.
And I agree that technology is a tool that is important for the judiciary to use to educate and to do its job better. Of course, technology, in particular social media, also poses a threat to the judiciary, because that's a way that some of the criticism of the judiciary, particular judges most especially, can really be magnified, and it can be a real pressure. But what I'd like to do is tie this back historically a little bit. I too am confident that the federal judiciary is an extremely capable, principled group, and will continue to act independently, both institutionally and individually on cases. I have every confidence in that. But that's not to say that there aren't a lot of pressures. There are a lot of pressures. And the pressures are fairly severe in some quarters. And there's a risk. There's a risk of eating away at the rule of law, eating away at judicial independence. And that's not easily recovered if it is impacted. And I think back to Hamilton, when he said, in basically saying that there isn't a reset button in this context. You can't lose judicial independence. Once the independence of judges is destroyed, the Constitution is gone. It is a dead letter. It is a vapor which the breath of faction in a moment may dissipate. And I think we need to bear that in mind and work hard to preserve judicial independence and the rule of law, because it is a foundation of our constitutional democracy.
Well, that's an excellent point to end on. Please join me in thanking Judge Wood and Judge Bates. All right. Thanks, Diane.
Well done.
That was good.
Yes.
Great. John?